MPs on the Commons Justice Committee have said the body which investigates miscarriages of justice, the Criminal Cases Review Commission, is being too timid and should refer more cases to the Court of Appeal. Our legal affairs correspondent, Clive Coleman, is here. And Clive, this is what? Because they fear there are too many wrongful convictions that aren't being picked up?
Well, there's a real fear that there are miscarriages of justice that are not being corrected. And the reason, Sarah, is that the Criminal Cases Review Commission can refer cases to the Court of Appeal if there's a real possibility that the conviction or the sentence will be changed. Now, currently the CCRC refers not very many cases at all, between 3 and 4% of its caseload to the Court of Appeal. The Scottish CCRC actually refers double that. Now, admittedly, the CCRC has a 70% success rate in the cases that it does refer, and it meets its key performance target. It's supposed to hit between 60 and 80% success. The Justice Committee says that this real possibility test is being applied just, as you say, too timidly, and that if a bolder approach leads to, say, 5 more cases, appeals failing, but 1 miscarriage of justice being corrected, then that's a real benefit. So in short, it's saying that the CCRC should err on the side of referring cases. It should never fear disagreeing with or being rebuked by the Court of Appeal, and it shouldn't worry really about its performance targets. Basically, it should man up and do its job.
Now, that's an extraordinary criticism or suggestion of what's going wrong.
It is, and I think that, it finds that the test is sort of being applied in the right way, but there is just an issue of timidity, and the CCRC should be bolder in what it does. Now, it also says that the Court of Appeal itself, its reluctance to overturn the verdict of a jury if there's no fresh evidence or no manifest irregularity, that also is something that bears on the mind of the CCRC, and it's calling for a review of the way the Court of Appeal goes about its business to be carried out by the Law Commission, but it certainly wants to see some change.
OK, Clive Coleman, thank you very much. We're listening to that is Richard Foster, who chairs the Criminal Cases Review Commission and joins us from Birmingham. Good morning.
Good morning.
Do you accept that you have been too timid in some of the judgments that you have made as to whether to refer something on?
I think the piece that we've just heard slightly misrepresents the fundamental findings of the committee. The committee said, and I quote, that in general we'd done a good job. It said, and I quote, that we're functioning reasonably well. It said, and I quote, that we were hampered by lack of resources and deficiencies in some of our powers. So the fundamental finding of the review is that we're doing an important job, we're doing a good job well, and that the main problems are around money and a lack of our Section 17 powers.
But it also said you should be referring more cases.
On the test, the main now, and bear in mind that we are required by law to operate a statutory test, so it's not our test, it's the test that Parliament has specified for us. On the test, its main finding was to raise a concern about whether or not the current test that we're required to apply is the right test. And they've suggested that the Law Commission should review that. And we've said that we would welcome a review. That's a sensible thing to do.
They have said, Mr. Foster, I just want to interrupt there because they have said, and do you accept that you should be referring more cases?
What they said about the test, and again I quote, is we have seen no conclusive evidence that the CCRC is failing to apply the test correctly in the majority of cases.
OK, but they're saying you should effectively ignore the test if we are to have sort of fewer miscarriages of justice.
The area of debate, and this is a debate, this is to some extent a legal debate, is whether or not the Court of Appeal, where a jury has convicted someone but there is no new evidence, whether or not the Court of Appeal should be more willing to simply go behind the jury.
Sorry, forgive me, Richard Foster, that's a separate issue, isn't it? Because irrespective of what the Court of Appeal decides, this committee is suggesting that you should be less timid. You should be more prepared, in a sense, to fail at the Court of Appeal. You should refer more cases. It may mean that you have 5 failed appeals for every one that is miscarriage of justice is corrected, but at least that would be one that was corrected.
The question you need to ask is this. The test we're required to apply is a statutory test which says that we should refer cases if, but only if, there is a real possibility that the Court of Appeal would quash the conviction. If we look at a case and we determine that we don't think that there is a real possibility, then there is no point in our referring that case.
That's fascinating. Can I ask you, so are there cases that come before you where you think there's something that's gone a bit wrong here, but I don't think because of the rules of the Court of Appeal it will get overturned and therefore there's no point passing it on?
No. There has not been a case where we have felt that there might be a miscarriage of justice where we haven't found a route for referral. I think your listeners might want to know that we actually refer one case a fortnight, and to date we've referred 378 cases, and that the overwhelming majority of the cases that we deal with are convictions of the most serious sort.
Okay, but can I just ask you about the comparison with the
so
Scottish CCRC, which refers double the number of cases that you do?
We refer on average about 3.5%. They refer about 7%. However, when you look at their referrals, nearly 50% of their referrals are sentence referrals as opposed to conviction referrals. So if you compare their conviction referral rate and the number of convictions that are quashed in Scotland with our conviction referral rate and the number of cases that are quashed in England, Wales and Northern Ireland, which we cover, then the figures are broadly the same.
Richard Foster, thank you very much.